Influencer marketing is only one of the business models that grew in the booming content monetization economy, where individuals are able to earn money through creating content for social media. In this video, we'll give you an overview of more business models and explain which consumer laws apply to you. We will also share some best practices depending on the type of activities that you perform. As we will also need to talk about one of the most debated legal issues, advertising disclosures, we've made a separate video just on that topic to help you be better prepared to deal with the laws that are important for your work. Based on our own research, we've mapped 5 main business models. Let's start with influencer marketing. Influencer marketing generally consists of advertising goods or services for money or advertising in exchange for goods, services, or other benefits. If you do influencer marketing, you probably use one or more of the following deals. Firstly, endorsements. That means you receive money to create ads on any kind of social media platform or website, whether the content is temporary, like Instagram stories, or permanent. Secondly, we have barters. That means you receive things like free hotel rooms or clothing in exchange for advertising or promoting a brand. This can also mean gifted products and services or public relations activities where you're invited to a restaurant or provided with a free video game to play on YouTube. Lastly, we have affiliate marketing. This means you receive a percentage of every single sale you drive, often based on advertising what is being sold. Often this is tracked to an affiliate link or discount code for your followers. The Unfair Commercial Practices Directive applies to all of these situations. Make sure to check out the separate advertising disclosures video where we discuss more details about influencer marketing as a business model and where we try to guide you with concrete advice about how to do responsible disclosures. On platform influencer marketing, some platforms like Twitch or TikTok now offer influencer marketplaces to bring together brands and creators. This leads to similar advertising disclosures or labeling issues that are covered by the UCPD, meaning you should follow the best practice advice that we gave you earlier in the video. Best practice. When you accept Twitch bounties or TikTok brand admissions, or once you start being paid for advertising services, whether with actual money or in algorithmic boosts, you need to disclose this deal to your audience. Subscriptions or tokens. When you set up subscriptions on platforms like YouTube, Twitter, or Patreon, or get micropayments during streaming on Twitch or TikTok, you engage in contracts for digital content with the consumers in your audience. The Digital Content Directive gives consumers more rights regarding the delivery or the quality of your content. For example, if you promise to have 2 calls with your patrons every month, if they pay you €100 and you fail to make that happen, this means there is a problem with the delivery of digital content. Consumers might have a right to be reimbursed for the services that they did not receive. If you promise to make 2 phone calls, you cannot substitute this with something else, for example, a signed picture. Similarly, there may also be problems with the quality of content delivered. If you promise to call for 5 minutes, then this must be fulfilled. Calls cannot last 30 seconds. Best practice. If you offer digital content through this business model, make sure you are aware of the quality and delivery standards required by law. To do so, you can check our Digital Content Directive videos and retrieve more information about this from our Influencer Legal Hub. Direct selling. This is a widespread business model that entails you selling goods and/or services to your consumer audience. As a seller who acts as a trader, you'll have to become familiar with a lot of additional rules, including the Unfair Contract Terms Directive, the Consumer Rights Directive, or the Digital Content Directive, to name a few. Selling goods to consumers as a trader means you need to facilitate a lot of information to consumers, which they need in order to make a well-informed decision. For example, the right to return goods according to the Consumer Rights Directive. The same goes for the rights consumers have when their products don't arrive or if they're defective. Best practice. If you engage in direct selling, there are literal lists of information categories that you need to comply with. Make sure to check our videos on the topic and check additional materials that we've prepared over at the Influencer Legal Hub to help you better understand what traders are supposed to do in these situations. Creator funds. If you happen to receive any revenue from platforms that have developed partner programs or creator fund programs such as TikTok or Pinterest, then this is a matter between you and the platform. There are no specific consumer protection issues that we've covered here. Ad revenue. Ad revenue is the same as creator funds. This is your contract with the social media platform that provides you with revenue from their platform advertising, for example, YouTube's AdSense. Since this is not advertising that you yourself engage in, there are no specific obligations for you relating to consumer protection when it comes to this business model. In addition to all the rules we mentioned here relating to different business models, it's important to remember that there's also an obligation to make sure that consumers are not harmed by the goods that you sell or advertise. The general product safety rules require all producers to only place safe products on the market. Some types of products might also be covered by more specific rules like cosmetics or toys. For instance, the cosmetic regulation establishes rules to be complied with by any cosmetic products made available on the internal market. Best practice. To make sure that you're not advertising or selling unsafe products, you can always check SafetyGate, the EU's centralized tool that national authorities can use to quickly alert the European Commission and each other about non-food products that pose a risk to the safety and well-being of European consumers.